now. Okay, thank you very much. And so yes, as explained, I'm going to be talking a little bit about the evolving challenges of regulating automated decision making. And now my slides are not moving. Sorry, we tested this before and it was working fine, and now it is not working. I can't seem to control them. Oh, here we go. Now it's working. Okay, sorry about that. Okay, so in the world of automated decision making, one of the challenges that we face are that the technology is changing so fast, as well as the ways in which it's being adopted and deployed, particularly for administrative decision making. And so today I'm going to talk about automated decision making with an emphasis on decision making in the public sector. I'll talk a little bit about the private sector too, but mostly on the public sector. And about AI governance in the public sector and the extent to which privacy law plays a role in this space as well. Just to set a little bit of context, we're in a period right now where governments, both federally and provincially, are signaling that AI and digital technologies will have a significant place in their agenda. And I've just given you a couple examples here, one from the federal government, which is has launched an AI strategy for the federal public service, and has clearly signaled that it wants to see adoption of AI within the public sector across Canada. And I've also given you an example from Quebec, where they also have a strategy for AI in the public sector. And this is typical. I believe Alberta has just announced as well its strategy for the adoption of AI in the public sector. It's partly because governments are interested in embracing in what they hope will be the efficiencies offered by artificial intelligence use in the public sector. I think it's also partly driven by economic concerns that adoption of and use of AI in the public sector will also help support the AI economy in Canada. There is, however, a trust gap in Canada, and this recent study by KPMG and the University of Melbourne ranked Canada 4th lowest among 47 countries in AI training and literacy, identifying this as a potential gap in Canadian policy approaches. Of the people surveyed as well, 79% were concerned about possible negative outcomes of AI. And 75% believed AI regulation was needed, with 92% being unaware of any laws that apply to AI in Canada. Now, there are actually a lot of laws that apply to AI in Canada, although there's little AI-specific legislation. But I find those numbers quite interesting in signaling a lack of trust, and there are other surveys that have flagged that as well for Canada in particular, a lack of trust in AI. So there's work to be done in this space. There's also a transparency gap, which I think is important to acknowledge. It's really difficult to know how much AI is already being used in the public sector in Canada, how it's being used, and by whom. And so I've put some links up on the screen. I'm happy to share my slides. My email is on the last slide, and if you'd like to get a copy of the slides, you can just send me an email, and I've got links to all of the things I reference. But there's a researcher at Western University, for example, Joanna Redden, who attempted to create a catalog of public sector and AI, which she's put online. It's a really helpful guide. It's got over 300 examples of public sector use of AI in Canada, most of which she had to find out about through access to information requests, and not because of any, proactive publishing by governments. The federal government has just announced that it's going to create a new AI registry for the federal public service, so it'll be interesting to see how quickly that gets up and running. And the goals of this AI registry are first to provide greater public transparency, so it'll be easier to know how AI is being used in the federal government. But it's also got the goal of helping departments and agencies avoid duplicative projects, because as they push for the adoption of AI in the public sector, there's this concern that different departments will be working on very similar projects, and if they pooled their resources or work together, they might more efficiently and effectively arrive at the solutions they're seeking. There's also the publication of federal algorithmic impact assessments on the Open Government portal. I'm going to talk in a bit about the Directive on Automated Decision-Making at the federal level, which requires departments or agencies at the federal level to conduct an algorithmic impact assessment before adopting an AI system and to publish that online. And you can find about 20 of these published online. And that doesn't reflect all of the AI that's being used in the federal government. So clearly some of these are not getting published in a timely fashion, but that's another effort at transparency. And in Quebec, there's a data set that's available publicly, which is a snapshot from 2024 of the use of AI in the public administration in Quebec. So that's another resource. But as you can see, it's very haphazard and spotty. And the Quebec data set gives you, would be a nice departure point for access to information requests, but it doesn't give you a lot of detail or information about the particular projects. So in terms of automated administrative decision-making, some of the benefits that governments hope to obtain from using automated decision-making systems include reducing backlogs and speeding up routine administrative processes. We all know that there are many, many systems within governments where people are applying for permits or for visas or for other things from government, and the delays are enormous and the processing times are very long. So speeding up those processes is seen as one of the potential benefits of automated decision-making. There's some hope that it will ensure fairer, more consistent decision-making, although I think, it's reasonable to ask to what extent that's going to happen, and we'll explore some of that in a minute. Improving public access to information and assistance is another benefit. But of course, there are risks that include things like bias and discrimination in decision-making, automation bias in AI-assisted decision-making, issues of transparency and explainability, the ability to even tell people why a particular decision was arrived at. I've added a return to legal formalism. We actually have evolved as an administrative state from the early days where the concept of legal formalism was that there was a set of rules and you applied the rules in a certain fashion and you arrived at an outcome. The administrative state evolved to recognize that sometimes human discretion was necessary to arrive at appropriate decisions. And so many administrative systems have built in this element of human discretion, and that's what the human decision maker brings to the table. And if we go back to automating decisions, or if we start automating decisions and implement a rules-based approach to decision making, we may lose that discretion. And so that, I think, is a risk as well. And of course, there are always cybersecurity risks. So one of the big questions then is, what role can AI play in administrative decision-making? And there are actually many roles. And I've identified some of these up on the screen, and I'm going to go through briefly and just give examples of some of these before getting into the nitty-gritty of governing it. So for assisted decision-making, so the system doesn't make the decision, but assists the decision-maker. You can have a number of different types of decision-making, assisted decision-making. Triage is a big one, where you have people applying for things, and there are going to be very simple cases, and there are going to be more complex cases. And the automated decision-making system can identify the applications, for example, that are complete or that have all of the elements that are required, and put them in one pile for a very quick review, and they can identify ones that are more problematic and put them in another pile, which will require greater attention. And so it can speed up processing in that way. And I've given the links here are to some examples for which there are automated algorithmic impact assessments online. And you see one of them is using AI to automate candidate evaluations and hiring. And I think that's an interesting example, and one where you can imagine there might be some serious questions asked. Recommendations or predictions. So this is another one where you're basically asking the system to make a recommendation about something, make a recommendation to the decision maker about a file or something in particular, and I've put up the Canadian Border Services Agency pre-arrival risk assessment of air travelers, where they basically attempt to predict which air travelers may raise question marks or be problematic. You'll notice I don't have a link to an algorithmic impact assessment because there isn't one posted online. Fraud risk identification, where your governments are using AI on their data to identify cases of potential fraud. And so these are examples of assisted decision-making. The system itself isn't making the final decision, but it's providing information to the decision maker. There is also automated decision-making, where you automate you create an automated system, rules-based. Usually this is for fairly simple types of decisions where it's, if somebody meets the criteria, then it's yes, and if they don't meet the criteria, it's no. Although there are ones where there could be more discretion required. And so these could include determinations of eligibility or non-eligibility for benefits or programs. And I've given a couple of examples. And the question is, really to what extent the state may start to move towards automated decision-making for more complex determinations. At the moment, there's a lot of hesitation about it, and there's a real preference for assisted decision-making and not automated decision-making. There are also uses of artificial intelligence as part of the process, for records keeping, for evidence. These are actually quite complicated and can raise some interesting legal questions. So there are obviously examples like transcription, translation, interpretation, and I've given you an example here of a voice-to-text application for RCMP transcription, translation of audio files collected during an investigation. Now you can imagine how something like that could actually raise some significant issues, and does in a lot of contexts. All of us have seen examples of AI transcription and translation, and it's not always, it's often very good, but there can be significant errors that affect the meaning of transcription and translation tools, particularly when people are speaking in non-standard ways with accents, for example, or if they have a speech impediment. And so this can raise some interesting issues. Another example is research memoranda, where background documents are being prepared for decision makers using generative AI. We all know what can go wrong with that. Assessments or evaluations, the risk of reoffending. I'll talk a bit more about that in more detail in a bit, but this is something that courts and tribunals use. They use risk assessment tools to help in thinking about these kinds of decisions. Evidence, including identification evidence through facial recognition technology. I've put a question mark next to credibility assessment because there's a lot of work being done on AI tools that can determine whether a person is lying or not. So picking up biometric data that suggests that a person is lying, and it's supposed to be much more effective than a lie detector test. And so at some point we may start to see credibility assessment being done by way of artificial intelligence, and who knows what else we're going to see. So there are a lot of these kind of process evidence type tools that will assist in decision making that can raise interesting issues as well. There's also the category of assistance and information to the public. In a sense, that doesn't look like automated decision making, but I decided to include it here. And an example might be a chatbot that provides information about programs, rules, options, recourses. I decided to include it because to the extent that it shapes and starts to shape how people apply for, object to, request, appeal, benefits or services, and that's shaped by their interaction with the chatbot. This could have, I think, implications for automated decision-making simply because you've got AI, which is helping to shape how people ask for what they need, and that could have an impact on outcomes. So, so those are just that's just a snapshot of some of the ways in which artificial intelligence may be used in automated decision-making. In terms of emerging approaches to governing AI in the public sector, I have put up here a number of different approaches. One is through risk regulation, taking a risk regulation approach. And the prime example we have in Canada is the Directive on Automated Decision Making, which was developed for the Federal Public Service, came into effect in 2019. So it's been around for a while. It's been revised and updated many times. And it's an interesting tool where the goal is to identify and mitigate risks in AI systems as they're being developed and before they're deployed, and then to monitor their functioning after deployment. So it's a risk regulation approach, which the idea is that you anticipate what the problems might be, you do your best to mitigate for those problems, and then you monitor your system to ensure that those or other problems don't manifest themselves. Something like that is anticipated under Ontario's Enhancing Digital Security and Trust Act, which was passed in 2024. They've created a very bare framework for a risk regulation approach, but it has to be filled out by regulations, and we're still waiting for those regulations. I've crossed off the AI and Data Act that was part of Bill 27, Bill C-27. This was the federal government's attempt to put in place for the private sector a risk regulation approach to the development of AI systems, which would have had an impact on the development by the private sector of AI systems for the public sector. But that bill died on the order paper, and the government is signaling that it's not coming back. So we don't have that anymore. And the EU AI Act is an example of AI risk regulation as well. Where there is no risk regulation in place, there are plenty of examples of ethics and principle-based approaches. I've given you some examples there from Quebec, Ontario, and BC, and there are many others. There are guidelines, and the federal government has released, for example, a guide on the use of generative AI for the federal public sector. And then there are existing laws like privacy and administrative law, and I'll talk about those in more detail as well in a minute. Human rights law I should have added to the list as well, because that's relevant. In terms of risk regulation and the Directive on Automated Decision Making, I'm going to move through this fairly quickly because it's really just a description of the DADM, and I'd like to get into more detail on some of the cases. But basically, just to give you a sense of how it works, it's the obligations under the DADM depend on the level of risk assessment. So the first step is to do a risk assessment and determine whether the system being deployed is low, moderate, high, or very high risk. According to the criteria in the document. Most of the more stringent requirements in the DADM are for high risk and very high risk systems with relatively few obligations, for example, for low risk systems and mainly transparency oriented obligations for the lower risk systems. This requires an algorithmic impact assessment. The DADM also imposes certain transparency requirements about providing notice of automated decision systems, explanations of decisions, requirements for documentation, and so on. But again, most of these obligations are for the higher risk systems. There are a range of quality assurance measures that have to be put in place for testing, data governance, data quality, gender-based analysis plus, training of employees, security safeguards, and for the higher risk systems, ensuring human intervention. And so it's got a range of requirements. It's a really interesting document, and I think done well, it can provide important safeguards. My only question is, how well is it done? And I've looked at some of them, the AIAs on file, and I think there's the algorithmic impact assessments, and I think there's real variation amongst them in terms of how attentively they are done. I mean, an algorithmic impact assessment can be a very thorough, rigorous and helpful process, or it can just be a box checking exercise. The requirements, again, for higher risk systems also require that there be individual recourse options and reporting on the effectiveness and efficiency of the system. And so it's an interesting approach, very useful approach for the design, development, and deployment of systems. But the focus is on avoiding or mitigating any risks or harms, not on remedying them. And so it's not a document or a tool that will provide remedies for the public if they're harmed by AI or if an adverse decision is made against them. And so that's something to keep in mind. There still have to be other recourses that are available, whatever those might be. Some have questioned whether risk regulation approaches actually offer benefits over conventional decision-making processes. We know that human decision makers can be biased, for example, but we don't do a lot of ex post evaluation, regular evaluation of how tribunals have been making decisions and looking for bias. And, you know, every once in a while, a researcher will have a funded research project where they look at, a number of years worth of decisions of an administrative agency to see if they can detect problems or trends or whatever in the decision making. But that we don't usually have those kinds of systems in place. And with automated decision making and things like the directive on automated decision making, there's actually the potential to have ongoing monitoring of the decision-making systems to ensure that they are operating within appropriate parameters and that there isn't bias or discrimination that's taking place. So there is a potential upside, and I think we need to have more experience with them to know just how meaningful that is. So as I mentioned, with risk-based approaches, there tends to be a higher level of obligation with higher risk decision-making. That maps onto administrative law principles where you owe higher duty of fairness, for example, for a higher risk or higher impact decision about an individual. So that's just a quick overview of the directive on automated decision-making. But of course, that raises the question, what is automated decision-making? To what kinds of things does the directive apply? And if we're thinking about recourses and remedies, like judicial review of administrative decision-making, what's an automated decision-making? What's an automated decision? And so the definition is kind of interesting. The directive on automated decision-making currently says that it applies to any system, tool, or statistical model used to make an administrative decision or a related assessment about a client. And I think that's really interesting. It's a change of wording from a previous version, which talked about a tool used to recommend or make an administrative decision. So in 2019, at the start of the directive, the concept was you'd have a system that either was making a recommendation to a decision maker or that was making a decision, whereas now we talk about or a related assessment. And I think that recognizes the variety of ways in which AI may influence the decision-making process, not just recommending, not just making decisions, but influencing in other ways through other assessments. The federal government has also produced guidance on the scope of the directive on automated decision-making, which says that systems, even seemingly simple ones, could be within scope when they replace or automate judgment or assist in the decision process at any point. Okay, so that's interesting and potentially quite broad. Or where they rely on rules or criteria that were developed by humans using their experience, judgment, discretion, and critical thought. And what they're distinguishing between here are simple rules. You have to be over 18 to get this type of permit, for example. That's a very simple rule, and you can automate that, and a machine can look at the evidence and say over 18, under 18. It's easy. But then there are rules or criteria that require human judgment, discretion, or critical thought. And so this is saying if this is part of a system that is relying on this type of rule, then it's automated, then it's within scope of the DADM. And systems that have developed rules or criteria on their own. And this is speaking to some of these more complex systems, neural networks, which once they're trained and set loose in the wild, start to make decisions, identify patterns and correlations, and make decisions in ways that the humans who built them didn't plan for and don't necessarily understand or are not able to detect. And so you've got a complex decision-making process going on that's not particularly transparent. And so again, the DADM would apply in that context. I'm just going to give you an example of an automated decision system that's received a lot of attention in the courts already on judicial review. And this is the federal government's, the Immigration, Refugee and Citizenship Canada, so IRCC, Chinook tool. And it's been quite controversial, caused a lot of headaches for IRCC. It's a tool that was developed by IRCC to improve efficiency in processing of applications. So again, this is one of those cases where you have visa applications, huge backlog. They want something to be more efficient. The decision makers are often in countries where there are broadband latency issues, and so it helps this tool can help address that sort of thing. And the IRCC, in frustration, they've actually got a website which tries to explain why they don't think this is automated decision making, and they basically say this is a Microsoft Excel based tool. This is not AI. This is Microsoft Excel. But all of us who use Microsoft suites or Microsoft products right now know that there is AI embedded throughout Microsoft's suite of projects. And I think it's becoming harder and harder to say that the tools, our desktop tools, are not AI tool, not also AI tools. And I think this shift and change and evolution of technology is challenging in this area as well. In any event, so they say it's just Excel. They also say the goal of the system is just to make the information available to decision makers, human decision makers, in a more user-friendly way, to simplify the visual representation of information. And they say it does not utilize artificial intelligence nor advanced analytics for decision making, and there are no built-in decision making algorithms. So they're saying this is not automated decision making because it's not used for decision making and there's no decision making algorithm. And then they insist that it's always the officer and not the tool that makes the final decision, and the tool is not even mandatory. An officer doesn't have to use it in order to arrive at a decision. So this is the Immigration Canada's justification or defense of Chinook as just a tool and not AI. There's a blog post by some lawyers for McCarthy Tétrault about Chinook, which notes that one of the things that Chinook does is summarize evidence submitted by applicants. And so sometimes the evidence can be quite lengthy documents, say a 20-page document, and the tool will produce a summary for the decision maker. And so right there, you have this question of, well, does having AI summarize a document submitted in evidence by an individual and presenting the summary to the decision maker, is that assisted decision, automated decision making? And the tool can also generate reasons for refusal. So if there's a decision to refuse, the tool will generate a set of draft reasons, which will be reviewed by the human, but it is still generating the draft reasons. The blog also notes that the introduction of Chinook coincided with a jump in the refusal rate for international students, and has a disproportionate impact on students from French-speaking African countries. Now, this is just from the blog, and I don't have the underlying data behind that, but I think it's interesting that they're raising these arguments. And of course, the directive on automated decision-making didn't apply to Chinook because it was in use before the DADM came into effect and was not grandfathered. My understanding is that IRCC is now doing an algorithmic impact assessment on Chinook in any event. It's caused so much pushback in the courts. And so, you know, as I mentioned, one of the issues is, does summarizing documents constitute assisted decision-making? Does generating reasons for refusal once the decision is made count as assisted decision-making? And how relevant is it in these circumstances that the final decision is always made by a human? How much in the context of human-machine interactions, do we trust humans not to be biased, for example, not to have automation bias, which is a demonstrated phenomenon where people start to trust the automated tools that they use and assume that the tool is always right. The Treasury Board has issued guidelines on the use of generative AI, which say that the directive on automated decision-making will apply where generative AI is used in automated decision-making, including to summarize a client's file or data. So from this Treasury Board guidance, it sounds like the government actually does think that summarizing evidence that's been submitted by parties is assisted decision-making that would fall under the directive on automated decision-making, as well as making a recommendation. Now, the same document says drafting emails is outside the directive on automated decision-making. So if you're using it to draft emails, correspondence back and forth in a decision-making process, that doesn't count. But my question here is, what about drafting decisions? What if you use generative AI for the first draft of your decision and your decision maker? And it's not clear where that would fit in. And the guidelines also say that generative AI may not be appropriate for use, and terms of service may prohibit its use for certain types of decisions. And that's certainly the case if you look at the terms of service of something like ChatGPT, for example. They say you can't use this for more for significant decision-making. Chinook has been in the courts under judicial review. I've mentioned there's been a lot of activity around Chinook in the federal court. And the courts have really struggled first with the question because the applicants are saying AI was used to make the decision about me, and I'm contesting it in part because AI was used. And so, you know, the IRCC is always saying it's not AI, it's not AI. So here's one judge that says, I agree the decision had input assembled by AI. So yeah, there's an AI dimension to this decision. But then the court says whether a decision is reasonable or unreasonable will determine if it's upheld or set aside whether or not artificial intelligence was used. And I think this is really interesting because from a transparency and accessibility point of view in terms of what an applicant will have access to, if you don't have any insight into the decision-making process, which may have been assisted by automation, you may have a decision that appears reasonable on its face, or is it within the range of reasonableness and therefore won't be overturned, but you don't have a lot of insight into how it was reached. And so one of the questions is, does that matter? Are we still just focused on whether the outcome is reasonable? Do we, and you know, the human was a black box too, to some extent. You don't really know what goes on in their mind. It's just about, is the decision justifiable? In this decision, the Artistani case, the court found that the decision was made by an officer with the assistance of Chinook. Whether or not there's been a breach of procedural fairness will turn on the particular facts of the case. And so again, the court is saying, yeah, okay, so maybe there was AI, maybe there wasn't AI, certainly Chinook was used, but let's focus on procedural fairness. And my question here again is, how do we focus on procedural fairness if we don't understand what the input was? Or do we just accept a certain amount of lack of transparency when it comes to the functioning of AI in the decision-making process? And so I think the courts still have to get a little bit deeper into the role of AI in administrative decision-making. And this case, Marara and Canadian Citizenship and Immigration says, at least in its current iteration, so the court is acknowledging that this is a tool that keeps changing. Chinook does not in itself provide information external to the application. So it doesn't. So the court seems to be thinking that it would matter if Chinook was being used to provide information about countries, perhaps from which applicants were applying, or about the applicant that's scraped from the web or something. Nor does it influence an officer's decision by reworking or making characterizations about the evidence. And that's interesting as well, because I'm not sure in the context of generative AI that summarizing evidence doesn't in some case amount to reworking that evidence. It's certainly not necessarily making characterizations about it, but you can certainly have you know, errors or issues with summaries of evidence. So that's the Marara case. There are at least 2 federal court decisions that demand some level of transparency regarding how evidence relied upon in an administrative decision was reached. One of these is Barr and the IRCC. This was a case where, and we don't know whether artificial intelligence, in this case in the form of facial recognition, was used in this case. This involved applicants whose refugee status, which had been granted, had been revoked by the minister on the basis that they had submitted a fraudulent application. And the main evidence against them was a facial comparison. The minister compared their photographs to photographs of two other people who had come to Canada from a different country on student visas, and basically was saying, you're the same people. And the applicants argued that the photo comparison had been made using Clearview AI, which was a software program that was that all, Canada's privacy commissioners have found violates Canadian privacy law and is no longer permitted for use. And so the IRCC, so in this case, the federal court was faced with this question of whether this illicit program had been used, and of course FRT has been known to be biased, particularly when comparing people with darker skin tones, which was the case here. And the court said the RPD reached a conclusion about the reliability of the photo comparisons based on the minister's say-so, with no further details about how the RPD's conclusion, which was void of transparency, was arrived at. The RPD's conclusion, which was void of transparency, intelligibility, and justification, must be set aside. So the minister's response was, we didn't use it. We didn't use facial recognition technology. And the court just said, you can't just say in a decision this important, which impacts people's lives in such a significant way, you can't just say, no, we didn't. No, we didn't. You have to actually show how you arrived at that photo comparison and that conclusion. Very similar result in the Ali case, again with facial recognition, or with concerns that facial recognition technology was used, but no evidence of this from the minister. And the court says high level of procedural protections required in this case, and the minister has to do a little bit better than just say we didn't do it. And in the Marara case, again, this was a little bit different, but here the court noted that the respondent's systematic daily deletion of all material generated by processing technology may not reflect best practice. The growing recognition that the exercise of public power must be justified would be hollow without a basic understanding of how the exercise of that power occurs. And so here the court is suggesting that there may be a duty to document and retain records of materials generated using generative AI in order to keep the system appropriately transparent. And I think that that's interesting as well. So you start to see these little granules in the cases. Now I'm going to skip over some stuff, ethics-based approaches, of which there are a number. Guidance, I've mentioned the Treasury Board guidance on the use of generative AI, which I think is really quite interesting, especially since it's a little bit, it's very cautious and concerned about some of the risks of using generative AI. Just to talk a bit, because I wanted to stop to leave enough time for questions. So I'm just going to say a little bit about privacy law and automated decision-making, because this is an area where the privacy commissioners in Canada have been very active. We're also seeing the right to an explanation emerging in privacy and data protection laws. It started in Europe in the EU AI Act and has carried over into Canada, but there are other areas of privacy law that may be relevant. So Bill C-27 that I've mentioned before, which we're actually expecting to see the privacy part of Bill C-27 reintroduced in Parliament in the next few weeks, maybe within the next month. We'll see, but it may be coming back. And if it does, we may be seeing this provision again. But this was for private sector automated decision-making, which would require provide for a right to an explanation. Now, the only things that I'll emphasize about the right to an explanation are that they really vary in terms of their scope, and they really vary in terms of what they provide. And so this one is, this first part here in C27 was just a general transparency requirement for organizations to post something on their websites in plain language. The second part would be triggered by the request of an individual, so not automatic, for an explanation. And the explanation would have to include the type of personal information used, the source of the information, and the reasons or principal factors that led to the decision. But there's no mention in this right to an explanation in C27 of a right to contest the decision or to request human review. It's just, you can request this information and it has, and this is what will be provided. Quebec has reformed both its public and private sector laws to include rights to an explanation. This is the one from the public sector law. It's the same as in the private sector law, just minor changes. And it's available for decisions based exclusively on automated processing. And so, you know, we've been talking about decisions assisted by, decisions made by. This suggests that it's just decisions that are based exclusively on automatic processing, so quite narrow in its scope. And in those cases, the person has to be informed of the personal information used to make the decision, the reasons and principal factors and parameters leading to the decision, and the right of the person concerned to have the personal information used to render the decision corrected. So a fairly limited scope of the right as well. But at least under this version, the person has the opportunity to submit observations to somebody who's in a position to review the decision. It doesn't say they have to review the decision, but the person, the individual at least has the right to submit observations to them. So a right to an explanation, but they're fairly limited. These ones in privacy laws, frankly, are fairly limited. What's interesting is that the privacy commissioners from across Canada, federal, provincial, and territorial commissioners, have all jointly issued guidelines on the use of generative AI. And those guidelines talk about the use of generative AI systems in decision-making processes, and require much more transparency than the privacy laws actually require. Now, these are just guidelines, but the commissioners, the aspirations of the commissioners are much higher than their legislation. And so they are calling for greater transparency about how the decision-making process takes place, the functioning of the system, and what personal information was used to retrain or refine the generative AI system for their specific use, indicating that the organizations will be directly accountable for those decisions made, that there should be an effective challenge mechanism for any administrative or otherwise significant decision made about them. And again, you can see how it goes beyond what's actually required in the laws, and provide an opportunity to request human review, again, going beyond what you would find in the laws. And so I think that that guidance is quite interesting, and it'll be interesting to see where we go in future with that. I just wanted to mention a few other cases. This one, Ewart in Canada, is a Supreme Court of Canada decision, and it's interesting because it involved the use of actuarial tools, so not artificial intelligence, but these were tools that were used to determine the likelihood that an offender would reoffend, or the likelihood, or to assist in deciding in what level of security prison an offender would be placed. And so you can see the comparison or analogy potential with automated decision-making. And the Supreme Court of Canada, in this case, interpreted this language in the Corrections and Conditional Release Act, which said that the service shall take all reasonable steps to ensure that any information about an offender that it uses is as accurate, up-to-date, and complete as possible. And the court found that this includes knowledge that could be derived from the tools. So if the tool predicts a certain outcome for an individual, then that becomes that individual's personal information. And there's an obligation to make sure it's as accurate and up to date as possible. In this case, the individual was Métis and had made an argument that the tools were potentially biased against Métis or Indigenous persons. There was some evidence from the United States that there were biases in the use of the tools against African Americans. And so the court actually found that the correctional services had not taken the steps necessary to ensure the tools were as free of bias as possible, and that the information that came from them was as accurate, complete, and up to date as possible. I find that interesting because, of course, all of our privacy laws have requirements for information about individuals to be as accurate, up to date, and complete as possible for the purposes for which they're being used. And so this kind of reasoning suggests that there may be also some recourse in automated decision cases under privacy law on the accuracy principle. There's also an interesting decision from the qu'elle in Quebec on using student data to train an algorithm to identify students at risk of dropping out of school. And essentially here, the qu'elle found that the predictions, a prediction that a student was at risk of dropping out of school, was new personal data that was being collected by the school board. And this is under public sector laws, so consent wasn't required for the collection of new data in that context, but there had to be notice, and notice hadn't been provided. And so, so it's interesting if we think about predictions and inferences and so on being new personal data in different contexts that may require notice. It may even require consent in some circumstances. And so once again, you've got privacy law offering some recourse in administrative decision-making contexts. So, and this is just from the same principles issued by the all of the commissioners across the country. They basically adopt this same approach that you see in the qu'elle decision, which is inferences would be considered new personal information. So it's an interesting result in that case. Now I promised to leave time for questions, and I think I'll briefly mention this case. And again, if you're interested and you want my slides, let me know. I'll send them to you. The links are there. This is a decision about, this was a complaint about an automated system used for proctoring, invigilating or proctoring exams online, which was adopted by most, similar tools were adopted by most universities across Canada during the pandemic. And these tools would monitor students and pick up on their eye movements, noises in the background to flag potential incidents of cheating. And there was a complaint to the Ontario Privacy Commissioner. And you know, you use what you've got. And you could complain to the Privacy Commissioner about these tools. There wasn't an AI commissioner to complain to. There was no separate route for complaining about the AI system. Most of the concerns, I think, substantively with these systems related to discrimination and bias and the creepiness of the systems, and it wasn't really a data protection issue. There were data protection dimensions, and the commissioner found a couple of breaches of privacy law. But went on to say that although there is no current law or binding policy specifically governing the use of AI in Ontario's public sector, I recommend that McMaster University, in this case, build in additional guardrails to protect its students from the heightened risks associated with its AI-enabled proctoring software. And I think this is such an interesting example of a privacy commissioner saying, I don't have AI jurisdiction, but nobody does, and I'm going to say some things about what I think should be done to make this a safer AI tool. And again, I think it's interesting. It's an indication of the enhanced role that privacy commissioners in Canada have been assuming with respect to AI technologies in a gap. And I think they do have a role to play with automated decision making. And so I'm just going to stop it there.